Okay, everyone, well, welcome. This is the next Region 2 educational event that we're doing, a legal update with the famous Gov Hutchinson. Gov, I'm not going to give you an introduction. You can introduce yourself. I'm sure most everyone knows you already. Just a couple of quick housekeeping items for everyone. If this is your first time on a Zoom webinar, you are muted and you are unable to share your screen. We can't see you. So if you want to interact with us, there's a Q&A button and a chat button. I'm already seeing that someone's saying that the sound is vibrating with an echo. I'm hoping when I mute myself, that goes away. If it doesn't, please let me know, and we'll see if we can troubleshoot. In the meantime, this is a legal update with Gov Hutchinson. You are being recorded, so mind your P's and Q's. As an advertisement for everyone, we are going to be doing an RPA form training later in the year. It'll be November 12th from 9 to 1. You'll be getting information from that from your association soon. We should be advertising that any day now. So if you're interested in the updated RPA form, Gov, I don't know if you'll be touching on that briefly, but we've got a class put together on that we'll be getting out to everyone. Additionally, Ellie Rosebush did an amazing job and has booked Gov for a second time this week to be doing a fire hardening class on Thursday. I'll be putting that information in the chat, so everyone keep an eye out for that as well. And with that, Gov, I'm going to mute myself and let you take it away.
All right. Hello, everybody. Good afternoon. Yes, you're going to see me again, hopefully, if you want to come at 10 o'clock on Thursday to talk about the fire hardening and the defensible space law and the form. I'll mention that today. I'll spend a couple minutes today, but on Thursday, that's all I'm going to talk about. So I know that's a big issue. So maybe you want to try to come back for that one. And yes, starting in about September, I'm going to be spending a lot of time teaching the RPA class. In fact, I think I'm doing the one November 12th that Andrew was referring to. So I'll be seeing you all a lot then. Unfortunately, the rest of this year, it looks like it's still going to be virtual. If you know me at all, you know I want to be out there where you guys are. And I think that's probably going to have to wait till next year, though, it looks like, because I got so many things to do. I just can't do it. But eventually, I'm going to see you guys all in person, which I greatly look forward to doing again. It's always been the best part of my job. But anyway, so today we're virtual, and I'm going to give you a legal update. I'm going to tell you what's new right now. The home hardening is just one of the things that's new right now you need to know about, okay? And put all your questions in chat. I will cut out, or Q&A, either one. I'll just take them as they come. I'd be glad to do that. And let's take it away. Let's get it over with. The latest on COVID, just to make sure we're all on the same page. The good news, as you all know, is all of those rules that you had to deal with for about a year and 3 months are all gone. I mean, they're pretty, you can do, with one exception, you can do everything you used to do before COVID. Open houses and showings and no PED forms and no cleaning and door knocking you can do, and broker caravans you can do, everything you can do that you used to do. Leaving off flyers, don't have to worry about social distancing. You don't have to worry about anything other than we still have the mask issue, because we still have California law regarding mask wearing. And remember, the basic rule is if you're vaccinated, you pretty much don't have to wear a mask. But if you're unvaccinated, you're supposed to. What am I talking? I'm talking about like showings and open houses. And it's really up to the seller and the agent how you handle that. I mean, remember, it's the seller's house, right? They can have whatever rule they want. They can say you got to take off your shoes. They can say whatever they want. No seller has to let you in the house unless you follow their rules. So some sellers, I'm sure, are still going to say, I'd like everyone to wear a mask when you come into my house, whether you're vaccinated or not. Or they're going to not be like that. They're going to say you only have to wear a mask if you're unvaccinated. and maybe they'll just have it the honor system, right? I mean, just like you're on your own. I assume if you're gonna come in my house and you're unvaccinated, you're gonna wear a mask. You know, I haven't heard of anybody really checking people at the door, but I guess that's a possibility too. I don't know, open houses where there are a lot of people there. I've heard of a lot of sellers just saying, okay, you know, at open house, I'd like everyone just to wear a mask. Makes it simpler. It's up to the seller. It's their house. So the seller and the listing agent, you should always have this conversation before you start doing showings and open houses as to how you're going to handle that, right? What about your real estate office? It's pretty much the same. When people come into your office, agents, vendors, clients, it's pretty much the same rule. And this is not just real estate offices, this is all offices everywhere. If you're vaccinated, you don't have to wear a mask. If you're unvaccinated, you're supposed to. And maybe the office is going to just use the honor system, right? They're going to put up a sign or something, please wear a mask if you're unvaccinated. They could theoretically check as people ask them as they come in, or check if they come in, but you can just have the honor system. It's really up to the business. It's up to the office, how you handle visitors, but it's pretty much the same as showings and open houses. There are a couple things though that you still have to deal with as an office, as a business. Number one, your office still has to have what's called a COVID prevention plan. You know what? You just download it off of our website, car.org, and there you go. You got your plan. And you still have to train your employees on safe practices. And you can just download our training stuff, which is part of that office manual on our website, car.org. Then and you can take care of that pretty easily. There are a couple of things you have to deal with as an office though, and this is not just real estate, this is all offices. One of them is if you have any W-2 employees, the owner of the office has to keep a record of who's vaccinated and who isn't. For your agents, independent contractors, you don't have to do that. For your visitors, you don't have to do that. But if someone works for you in your office, they're actually physically in the office and they're a W-2 employee, you have to just ask them if they're vaccinated or not and then keep a record. How long do you have to keep this record? Nobody knows. Who do you have to give it to? Nobody knows. But it's just the rule. Just keep the record. Now, same thing, you should require your unvaccinated people who work there to wear a mask. Now, some employers ask me, well, what if, can I just say to someone, if you're unvaccinated, you can't work here anymore, or you have to work from home? Yeah, you could do that. Melanie, clearly this is not a HIPAA violation that's been seriously researched and determined. It's not a HIPAA violation to do this. What's a HIPAA violation is for you to share someone's information with somebody else. So you're not going to share this information unless you get audited or something. But you as the business owner have to, for your W-2 employees, you have to ask them if they are vaccinated and keep a record. And the other thing, it's just kind of crazy, but get this. Let's say you have an unvaccinated employee and you're letting them work in the office. And they say to you, hey, could you give me an N95 mask? You, the business owner, have to supply them with an N95 mask only if they ask for it. Isn't that interesting? And by the way, within an office, if you're unvaccinated, then wearing a mask, you can still take off the mask if you're by yourself in an area, you know what I mean? You're by yourself, like in a sub office, or you're eating, just like in restaurants, you can take off your mask if you're eating. Okay, so that's the latest on COVID. Next thing I want you to know is the latest on evictions. You probably heard, we thought the eviction moratorium was all going to end on the 1st of June. Obviously, the federal eviction, the nationwide eviction moratorium was extended till July 1st. And the California one was extended until the end of August, September 1st. The federal one, when they extended it 1 month, they basically said, that's it. Now, you may have heard that there was a it actually went to the US Supreme Court challenging the federal eviction moratorium. And the US Supreme Court basically said, it's not really constitutional, but since it's going to expire at the end of July, we'll let it go for 2 more weeks. End of June, July, we'll let it go for 2 more weeks. But we don't really care in California because we have a state eviction moratorium, which is going to the end of August. That hasn't yet been challenged in court. Well, it's been challenged, but haven't had a resolution yet. So that pretty much will probably still be in effect for at least till September 1st. Will it be extended beyond that? I doubt it, because the legislature won't be in session. So unless they have a special session just for that, which I think is unlikely, it's probably going to expire. Now, if you were down here where I am in Los Angeles, there's a local rule, which is already going to go past June 1st. But I don't think up there in Region 2, you got, as far as I know, you don't have any local eviction moratoriums. So we just have the California one, which basically just continues for June, July, August, and September. I'm sorry, for June, July, and August. The basic rule of you cannot evict someone in a residential property for not paying rent if the reason they're not paying is COVID related. How do you know if it's COVID related? You send them the pay rent or quit COVID form, the PRQTP for transition period. They have 15 days to respond. If they respond with a declaration, you can't evict them. What if they're not paying rent for some other reason? Well, you can evict them right now. What if they're not allowing me to show property? Evict them now. What if they're committing a crime, nuisance, damaging the property, subtenants they shouldn't have, pets they shouldn't have? You can evict them right now. You can evict for cause right now, unless the cause is they're not paying because of COVID. And even then, they got to pay 25%. Well, if they don't pay the 25%, can I evict them now? No. You can only evict them in 2.5 months or 1.5 months. Okay, so there's another important thing to know, and that is this new law. It didn't just extend the eviction moratorium, it made a couple of new things. One of them is every landlord in California, if you have a tenant that owes you back rent for COVID, you have to send them before the end of this month a new disclosure form. It's called the NTRA 3. Yes, you've already sent them the NTRA and the NTRA 2 in the past. Now you have to send them by the end of this month the NTRA 2. Okay, 3. I'm sorry. It's a disclosure form regarding the tenant's rights, but if you don't send it, you're not going to be able to evict them when the time comes, or you're not going to be able to sue them for the back rent when the time comes. You see what I'm saying? So please send them that form as soon as you can, the NTRA 3, if they owe you money, back rent for COVID. Okay. Now, what about tenants who aren't doing anything wrong? Can I evict a tenant just because I want to evict them? Just because I want to sell the house? Normally, of course, the answer is yes. You don't even need a reason. But for the next 2.5 months, we still have this requirement in California that if you want to evict someone who's not doing anything wrong, you have to have a reason. And there's only 3 legit reasons, really. Number 1 is the owner wants to move in, but then they really have to move in for like a year or so. Number 2, you can take the house off the rental market and not rent it to anybody but then you'd have to keep it off the market for 2 years. Third, though, best thing for realtors is if you have a property for sale and you get a buyer who signs an offer and the offer says the buyer is going to live there, as soon as your offer is accepted, you can give the tenant a notice, 60-day notice. Okay? So owner occupying buyer in contract is grounds to send a notice to terminate right now. Okay? You have to make sure you're using the right form there. You have to make sure you're using the NTT, Notice of Termination Tenancy, CT, Tenant Relief Act form, the TRA. Bottom line is this. In this complicated situation we're in right now, don't try to figure out which form to send the tenant, to send them some type of notice. Call a lawyer, call the legal hotline, tell your client to call the lawyer, better yet. It's very complicated on what form you need to use before you can send someone a notice. First of all, it's complicated to know when can I send them a notice. Number two, what form do I have to use to do it? It's quite complicated. Now, but there's good news here. The good news here that changed is every landlord, not every landlord, a lot of landlords in California are entitled to government money, rental assistance, to compensate you for all the rent you haven't been getting from your tenants who haven't been paying because of COVID. There's a website, housingiskey.com. You go to housingiskey.com, you look up your county. I know on this call we got several counties. Look up your county, or maybe look up the city, and it'll direct you how to apply for this rental assistance. It'll also ask you for your tenant's email address because the tenant has to apply also. So you apply for this assistance, and if your tenant is eligible, the government is going to give you 100% of the rent you are owed, all the way back to March of 2020. Now, remember it used to be they only give you 80%. Now they're going to give you 100% of the money you are owed. The only catch is this only works is if your tenant's income right now or during all of last year is less than 80% of the county income for a tenant household of that size. Let's say you got a tenant household of 4 people in San Luis Obispo County, and they haven't been paying you, and you want the government to compensate you for all the back rent. Well, so you go to the website, you look up San Luis Obispo County or the city you're in, you fill out the application, they'll send an application to the tenant. Then the tenant's going to put down what their income is. And it's either what their income was for all of last year, or what's their current income, current monthly income. You know what, maybe the tenant got laid off a month ago, they don't have any income right now. They're clearly going to be less than 80% of the area median income. Or maybe last year for a few months they were laid off, whatever. So their overall income for last year was less than 80% for the average, the median income for a tenant household of 4 people in San Luis Obispo County. However it is. And by the way, if you want to know what that number is in your county, you can just Google it. You can call the hotline. We can totally help you. It's on our website as to what the county, what 80% of the county income is in every county for tenants, households of various sizes. Let's say you have an eligible tenant. Then great, you're going to get this money. Okay. Here's another catch. 3 months from now, 2.5 months from now, when you can start evicting people, if you try to evict them with a 3-day notice, you're going to have to, you can't send the 3-day notice until you've attempted to apply for rental assistance. You see what I'm saying? And in other words, you have to wait at least 20 days after you've applied. to see if you've either been rejected or maybe the tenant didn't apply. By the way, some tenants for some reason are not applying, they're not cooperating. If the tenant doesn't cooperate, you're not going to get the assistance. You would think the tenant would cooperate. Why wouldn't they want you to get the money? That means they don't owe the money anymore. Anyway, the point is, you got to wait basically 3 weeks. Then you check with the county to see if the tenant has applied or if you've gotten rejected. If you've gotten rejected or the tenant hasn't applied, then you can do the 3-day notice. Same thing. Let's say, 2.5 months from now, you want to sue the tenant for all the back rent. You'll be able to sue them, but you won't be able to sue them until you can prove that you got rejected for the rental assistance or your tenant didn't apply. I mean, if you apply and the tenant applies and you get the rental assistance, obviously you can't sue the tenant. You can't double dip. You can't sue the tenant for the back rent they owe you if the government just gave you that money. But when this eviction moratorium ends, they have to pay 100% of the rent. And if they don't, you can evict them, okay? Plus, you'll be able to evict people for other reasons too. If you're evicting them for other, or you don't need a reason, this requirement of just cause will be gone, in which case, great, you can just evict them. But if you're evicting them for non-payment of rent, you're going to have to prove that you applied for rental assistance and you got rejected or the tenant didn't apply. So those are the two big new things. You got to provide this form, this disclosure form, if the tenant owes you money for COVID, the NTRA 3, and there's going to be this, you have to apply for the rental assistance if you want to try to do a eviction or sue them in small claims for the back rent. Okay. Hopefully this is all going to go away soon. And then, but the only thing that's still going to be remaining until March of next year, even if this all goes away and you can evict people for no reason anymore, and even if they have COVID, you can evict them, even if that goes away, if you're going to be evicting people who didn't pay COVID rent, you're still going to have to apply for rental assistance before you can evict them. And that's going to go till like March of next year. Okay. Yes, we have a Q&A explaining all this. You can call the legal hotline. There's rental assistance and there's eviction moratorium. Okay. All right. Enough with COVID. Enough with evictions. Enough with this COVID stuff. Amy, this only applies to residential. This doesn't apply to commercial. Okay. Commercial is back where you used to be, but there's no rental assistance either, unless your particular county has anything for that. Okay. All right. Let's talk about not COVID stuff. Let's talk about new laws and new forms. As you know, the forms change twice a year at CAR, end of June, end of December. You already know what's going to happen end of December. New purchase contract. And all of the forms that are connected to the purchase contract also are going to be updated. It's going to be one big package. You should probably come to the class on November 12th so you can go over all this stuff. We're also going to be doing a weekly free webinar starting, I think, in October. So we're going to be a lot of information out there. You should probably all attend it. But anyway, that's what's happening end of December. What about right now? What about forms that changed or came out new end of June? Well, the big one is the fair housing. I'll talk about that in a second. But other than that, there was only one new form. It's called the Transfer of Listing Form, TOL. It's not a mandatory form, but let's say you got an agent has a listing and they want to change offices and they want to take the listing with them. Or you have an agent coming from another office to your office and they want to bring the listing to you. First of all, the broker doesn't have to allow that, right? The broker can say, no, it's my listing. If you leave it, you got to leave the listing. But maybe the broker is okay with someone taking the listing with them. Now there's a nice form everybody can use to make this official, right? it takes care of transferring the listing, takes care of release of liability, or it takes care of agency, it takes care of transferring the files, and it takes care of compensation. Maybe you're saying, yeah, you can take the listing with you, but I want to get paid something when it sells or something like that. You can take care of it all in this nice form, and that would be good. Kayla, I'm giving you a question. Purchase agreement is accepted for a non-buyer occupied home. In other words, the buyer wants to buy the property, but they're not going to live there, right? In that case, you cannot give the tenant the notice until the end of the eviction moratorium. Doesn't matter about whether there's problems with the tenants or COVID. You simply cannot evict a tenant right now unless you have just cause. Just cause means they're doing something bad, they're not paying you and they don't have a COVID reason, or owner move in, take house off the market, or I'm in contract with a buyer who's going to live there. If you're in contract with a buyer who's not going to live there, that's not grounds to send the notice. You can't send the notice until September 1st, okay? What about, Wendy, what if it's a duplex? In other words, I guess you're asking me, well, okay, so what if you got a duplex and you just want to take one of the units off the market? Well, you could do that. But then that unit is off the market, off the rental market for 2 years at least. So you could then sell the property, but the buyer of the duplex, one of the units which is off the market, couldn't rent that out. Now maybe that works. Maybe the buyer wants to buy it and live in the unit that you took off the market. They couldn't rent it out for a couple of years, but that might work, right? If that's what the plan is. Okay. All right. What about, are there any other new forms that came out? Well, I'll talk about the fire hardening in a second. No. Are there any forms that you use that got changed end of June? Yeah, well, a couple forms. First of all, your listing form, the form that you use all the time, the listing form, has 3 changes on the listing form if you didn't notice yet. One of them is, it's in the old days, I guess in the recent past, typically as a seller, you wait till you get a contract, you wait till you're in escrow before you start ordering things like the prelim and the HOA docs and NHD report and things like that. But it's become more common for, as soon as you take the listing, before you even sell it, that the seller orders these NHD prelim and all that stuff. Well, now you'll notice right on the listing contract, there's check boxes so the seller can indicate right on the listing that they're authorizing the listing agent to order this stuff early at the time of the listing rather than at the time of a sale. There's another new paragraph on there dealing with the concept of days on market. Some sellers, when they list with you, they got this concept in their mind of what they think they understand days on market to mean. But it's not always correct because different MLSs define it differently. So there's just a paragraph on there that says, it's talking to the seller, it says, seller, if you have questions on what days on market, you should talk to the agent to understand what that means. Now, one day in California, we're probably going to have a standard definition of days on market. And when that happens, the listing contract will be tweaked for that purpose, okay? But at this point, no. Just like, what else is going to be eventually, hopefully, a universal rule on what coming soon means. What can I do under the coming soon status and what can I not do under the coming soon status? Right now, it sort of varies from MLS to MLS Hopefully we'll get some uniformity on that. But anyway, let's get back to the listing contract. The third thing that changed on the listing form is there's something on the listing form now regarding these so-called buyer letters. I don't know if it's prevalent in region 2, but the Bay Area certainly, and in LA certainly, there's when buyers write an offer, they don't just, a lot of times they don't just submit an offer, they submit a letter, dear seller, a personal letter to, sometimes they call them love letters, where the buyer talks about themselves and says, you should sell to me and my beautiful family because, you know, my husband and my 3 beautiful kids, and we do this, and we're from here, and we're the blah, 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 blah. Trying to convince the seller, you know, pick me over other people. And you may say to yourself, well, what's wrong with that? The problem with that can be that when the buyers disclose personal information about themselves, like, oh, we got 3 kids and we're from Kentucky, or I'm a dentist and whatever. One of my children is disabled, whatever. You disclose personal information. Ideally, the seller shouldn't really know that personal information, because sellers under the fair housing laws are supposed to make their decision on which offer to accept, not based on the personal characteristics of the buyer, but based on the objective features in the offer. I mean, we're all biased unconsciously or consciously. And it's like, the idea is sellers should be ideally not know that much personally about the buyer to influence their decision. Did you know the state of Oregon this week actually outlawed these types of letters? California, they're perfectly legal in California. It's just that if I'm a seller and I get these letters, that might put me at risk, because then I could be accused later and say, well, why didn't you sell to me? Oh, I guess you didn't sell to me because you don't like families with children or whatever. You don't like people from Kentucky, or you don't like dentists or whatever. So if I don't know that information, nobody can accuse me of being biased. You see what I'm saying? So the idea is, maybe this is something you should think about, that maybe it's not a great idea. That doesn't mean it's illegal. The seller has a choice. So now on the listing form, there's a place where the seller can make a choice. They can say to their agent, you know what? Please don't forward these letters to me. In which case the agent could even put in the MLS agent confidential remarks, please don't submit letters. Or the seller might say, no, I want the letters. I understand the issue, but I still want the letters. So the seller can choose on the listing form what they want. Okay. All right. Any other forms that are changing? We'll be interested to know that the statewide buyer and seller advisory has 3 new paragraphs. One of them deals with sea level rise. I don't know if any of you guys sell properties on the coast, but you know, in the future, there's probably going to be sea level rise, which might affect the homeowner's ability to build on the property or improve the property. So now there's a disclosure telling the buyer, the seller, whoever gets this form, that, you know, be aware that when you buy property on the coast, you could be subject in the future to regulations restricting your ability based on sea level rise. There's another one that's interesting that says, you know, there've been a lot of cases, I don't know about where you guys are, probably more you are than where I am, where, you know, wildlife wanders onto the seller's backyard, or they wander into the backyard, you know, bear, coyote, whatever. And you know what the homeowner does? They sue their agent, say, well, you didn't tell me that could happen. Well, now there's a clause in that form that says, you know what? In California, it's possible wildlife can come onto your property. And then there's another one on home hardening, which talks about the home hardening issues, which leads me to, let me talk about that. Okay. The most significant new law that's happened this year, other than all this COVID stuff and all this eviction stuff, and I'm going to spend, those of you that want to come on Thursday at 10, I'll go into a lot more detail. But let me spend a few minutes, is this home fire hardening and defensible space law and form. I think we got to put it in perspective. As we all know, in California now, there are a lot of fires. And there are two things that homeowners can do to protect themselves. One is they can so-called do fire hardening, put in dual pane windows and get rid of the wood roof and things like that. And another thing you can do, another thing that you have to do, you're required to do in certain areas, is to maintain defensible space. So there's fire hardening that's recommended, and there's defensible space, which is required. So what happened this year is the government said, well, we're going to come up with a couple of laws that really try to encourage people to comply. The first was the fire hardening part, which took effect January 1st. And there was this, for the last 6 months, there was this home fire hardening form, right? The HHDA. And then effective July 1st is the defensible space law. Now, the fire hardening law is just a disclosure. So there was this form that you were supposed to give your buyers in the first 6 months, but it's just disclosing. Whereas the defensible space sometimes actually requires somebody to do something. But it's still basically a disclosure. So the fact of the matter is, what that means is we now have 6 mandatory disclosure forms in California rather than 5. For the last 15 years ago, we've had 5 big disclosure forms, right? The NHD, which you typically order from a third party, the TDS, transfer disclosure, the seller property questionnaire, which is not required by law, but it's required in the purchase contract. Number 4, the lead paint form, which was required in all pre-78 sales of pre-78 properties. And number 5, there are these disclosure booklets that are required. NHD, TDS, SPQ, lead, and booklets. Well, now we have a 6th one. It's the fair housing and defensible space. That home hardening form is gone. It's been incorporated into the FHDS. So the new form takes care of the home hardening disclosure, and it takes care of the defensible space. But unlike the other 5 disclosure forms, this one is only required if you're in a very high or high fire zone. Everyone in California, we're either not in a fire zone, or you're in a moderate zone, or you're in a high zone, or you're in a very high zone. This form is only required in the last 2. If you're in a moderate fire zone or you're not in a fire zone at all, the form is not required. If you're in a very high or high, the form is required. So now what that means is every time you take a listing on residential 1 to 4, it's not required on more than 4 units, not required on land, is required on mobile homes. So I'm listing residential 1 to 4, including mobile homes. I got to figure out now, is this property in a high or very high fire zone? If it is, you need the form. How do I know if it is? You check with your NHD company. The NHD form itself discloses if it's in a very high. If neither firebox is checked on the NHD, you're not in a fire zone. If the very high is checked, you're in a fire zone, got to do the form. If the very high isn't checked, but the wildland fire zone box is checked on the NHD, that means you're either in a moderate or a high. Well, how do I know which one I'm in? You got to push a little further with your NHD provider, and they will tell you which one you're in. So let's say you figured out you're in a high or a very high. So you pull out this form. You got to fill it out. But the next thing you got to ask yourself is, was this house built before 2010 or after 2010? If it was built after 2010, the seller doesn't have to answer the 6 questions on paragraph 3 regarding fire hardening. They still got to provide the form, but they don't have to answer the questions in paragraph 3. Thursday, when we do this, we'll have the form in front of us. We'll show you. The form is required regardless of when the house is built, but the seller only has to answer the 6 questions in paragraph 3 regarding fire hardening if the property was built before 2010. Okay, but paragraph 4 regarding defensible space is required no matter when the house was built. So the first thing on your checklist, number 1, you've figured out if you're in a high or very high. Let's say the answer is yes. The second thing on your checklist, you figured out when was the house built. If it was built before 2010, you basically tell your seller you have to answer these 6 questions. Check these 6, check the relevant boxes in paragraph 3. Then the next question you have to ask yourself is, let's talk about defensible space. We come to paragraph 4 of this form. And if you've looked at the form, and on Thursday we'll be all looking at it, they got paragraph 4A, which is just information. 4B has 4 subsections: 4B1, 4B2, 4B3, 4B4. The seller has to determine which box to check. Either they're going to check 2, 3, or 4, or if they're not going to check any box, it defaults to 4B1. 4B1 is the default. If you don't check any of the other boxes, that's the relevant box. What determines what box I check? Well, what determines it is a couple things. Number 1 is there a local, first of all, there's a California law, right, that requires 100 foot of defensible space in certain areas. But there's also some counties, I know Napa, I know Sonoma, I know Mendocino, Marin, San Bernardino, Riverside. I don't know specifically about counties up where you are, but there are a lot of counties that have defensible space rules, local rules, which are sometimes in addition to or stricter than the state 100 foot. So you got to figure out if you have a local ordinance. But just because there's a local ordinance doesn't mean anything. It's only relevant to this form is if the local ordinance requires either the seller or the buyer to obtain documentation that you're in compliance with the local law. And all these places I've mentioned, the only place I've found so far is Truckee, where there's actually a law, a local law that requires you to actually do something regarding the local defensible space. I'm not aware of everywhere. We haven't checked everywhere yet. I'm just telling you. So as a listing agent, number 1, you figure out, is there a local rule here? And does this local rule require the seller or the buyer to do something other than to be in compliance? I mean, obviously you have to be, we all have to be in compliance with defensible space. Forget this new law. Right now, last year, 2 years ago, 5 years ago, if you were not in compliance with defensible space, CAL FIRE or a local fire company could come out to your property, and if you're not in compliance, they could fine you right now. All this new law says is when you sell a property, that might trigger an obligation to go out and get documentation. Now, if there's a local law, if you have a local ordinance that actually requires you to get documentation, then the seller's going to check paragraph 4B3 or 4, depending on whether it's the seller's job to do it, like in Truckee, or it's the buyer's job to do something, which we really haven't found any of those yet. Most of the time, when you sell a property, there probably is no local ordinance, or there's no local ordinance that requires any specific documentation. For example, yesterday I was talking to people in the Big Bear area, and they have annual inspections for defensible space that comes out by the government. They happen whether you call them or not, they just show up. but they don't require that you to get any documentation. They just tell you if you're in violation, you better fix it. So that law doesn't affect this form at all. What's important to know here is, let's say there's most of your transactions, you're in a very high zone, but there's no local ordinance, or there's no local ordinance that requires you to get documentation. That means it's either going to be 4B1 or 4B2. So remember, on your checklist as a listing agent, the first thing you did is you figured out that you're in a very high zone. Number two, you figured out how old the house was, so you could decide if the seller had to answer the questions in paragraph 3. The third thing you figured out is is there a local ordinance requiring me to do something? And chances are, if you're not near Truckee, you probably don't. Then the one last thing you have to figure out is, now we go to paragraph 4B1 or 2. This is talking about compliance with the state 100-foot defensible space rule. So the fourth thing you're going to do is you're going to ask your seller, hey, seller, has anyone come out to this property in the last 6 months and done some type of inspection and actually given you something in writing saying you're in compliance with the state law? And there are a couple places where people do some CAL FIRE comes out randomly and they just do this, or local companies come out randomly. So you're going to ask your seller. They say, yeah, 4 months ago, they came out here and they checked me out and they gave me a piece of paper saying I was good. Well, if that's the case, you're going to check 4B2, and the seller's going to give that document to the buyer. I suspect usually that's not going to happen. Usually the seller's going to say, nope, no one's been out here in the last 6 months. In which case you default to 4B1. 4B1 says buyer shall obtain documentation of compliance within a year after close. So listing agent, you're done. You've not checked any of the boxes and you've delivered the form to the buyer. You're done. What's now happened is the buyer is agreeing to do something in the next year after close. Listing agent, is it your job to make sure the buyer does that? No. Buyer's agent, is it your job to make sure your buyer does what they're supposed to do? No. Buyer's agent, it's probably your job to at least explain to the buyer what they just agreed to. Say, hey, buyer, did you notice on this form 4B1 says within the next year you're going to do something? Buyer says, what am I going to do? You're going to call CAL FIRE if you're in a state responsibility area, or you're going to call the local fire company and ask them to come out to the property to give you documentation, to check you out for defensible space, so you can get documentation you're in compliance. Buyer might say, can I do that before I even close? And the answer is not without the seller's permission, because the purchase contract says you can't call out the government without the seller's permission. The seller may say, no, I don't want you doing that. They may come out and they may find the property's in violation. They're gonna fine me. So they're probably gonna say, no, wait till after close. Then the buyer's they're gonna tell the buyer, after it closes, call CAL FIRE. They'll tell you if you're in a state area, and they'll also schedule, they'll come out and do it. Because we've talked to CAL FIRE, they're ready for this. They've hired inspectors, they're ready for these calls. But what if the buyer calls CAL FIRE and CAL FIRE says, sorry, your property is not within our jurisdiction? So what you would do then is, as a buyer, well, I guess I better call my county or city fire department and see if they'll come out. What if you call your county fire department and say, no, we don't do that. We don't come out randomly upon request. We just come out when we feel like it. In that case, get the name of the person who told you that, write it down, you're done, buyer. So as a buyer's agent, you probably want to explain this to the buyer when they get this form. It's probably your duty to do that. But once escrow closes, the buyer's on their own, okay? Which leads to one question. What if you give this form to the buyer and the buyer says, I'm not signing. I refuse to sign because I don't want to commit to do this. Now what? So I asked CAL FIRE, I said, if the deal closes and the buyer won't sign it, is there any ramification against the seller for allowing a deal to close, even though the buyer refused to sign it? You know what Cal Fire told me? Oh, we're not sure about that one. So you know what conservative Gov would advise you? I would say, if I was a seller and I gave this form to the buyer and the buyer won't sign it, I may not sell to them. I may say, hey, the purchase contract says you must sign and return all disclosures. If you don't sign it and return it, you're in violation of the contract. I'm going to give you a notice to perform. 2 days later, I'm going to cancel the deal because I don't want to take a chance that I'm going to have a problem after close because you didn't agree to go out and do this within a year. I don't know if Cal Fire is going to come after the seller. Personally, I doubt it very much. I'm just saying I'm being real conservative here. Okay. I will go into this a lot more detail, believe it or not, on Thursday, but that's sort of a 15-minute version. Maybe that's enough for you. I don't know. We got a Q&A, or I'll see you Thursday. Okay. Let's talk about other things. Prop 19 is generally a good thing for you. Remember what Prop 19 says? It says, if you're over 55 or severely disabled or the victim of a wildfire, you can sell your house, move anywhere in California, and take the low property tax with you to the new house. And you can do it 3 times, and you can move anywhere, and you can even do it if the new house costs more than the old house. I'll give you an example. Let's say you bought a house long time ago, for $50,000. You're paying property tax based on $50,000. It's now worth $400,000. Under Prop 19, you can sell your $400,000 house, move anywhere in California, buy another house, and take the property tax that you're paying on the $50,000 that when you bought that house a long time ago to this new house anywhere in California. And you can do it 3 different times. And you got 2 years between the sale and the purchase, and you can even buy first and sell later, as long as you do it within 2 years. That's if I sell my house that's worth $400,000 and I buy another house worth less than $400,000. Well, what if I want to sell my $400,000 house and buy one for $500,000? What's my property tax basis going to be on the new one? Well, it's going to be the original 50 plus the difference between the purchase price of the new one and the sale price of the old one, which is $100,000. So you add that to the 50, my property tax basis on the replacement property is going to be $150 rather than $500. Or maybe my house is worth $1 million now, even though I bought it originally for $200,000. And I sell my $1 million house, I buy one for $1.1 million. My property tax on that $1.1 million house is only going to be based on $300,000, the original $200,000 plus the $100,000 difference. This is not automatic, by the way. If you do this, you have to go to the assessor's office and fill out a form, but then you can take advantage of this transfer on Prop 90. Remember before Prop 19, you could only do this once, and you had to stay in the same county. And if the new house costs more than the old house, you couldn't do it at all. So it's a lot better now. So that's a good thing. Make sure, maybe it's a way to get a listing. Get someone who says, oh, I don't want to sell because my property taxes are going to go way up. Well, maybe not. You know what I mean? Okay. So that's Prop 19. Other things you should talk about, we'll talk about real quick. I don't know if in your area, like a lot of areas, you're having as many multiple offers as we see in a lot of places. We're seeing 3 big things that are getting people in trouble. Number one, they're making non-contingent offers without understanding what that really means. What that really means is you can buy the house, you find something you don't like about an escrow, you still got to buy it. Although be aware that if you make a non-contingent offer, you can still cancel the deal within 3 days after receiving the statutory disclosures. What are the statutory disclosures? The TDS, the lead paint, the NHD, and this new FHDS. But if a seller provides these disclosures to the buyer before the buyer signs the offer, they don't get this 3-day right of rescission. So if they make a non-contingent offer after receiving all the disclosures before they even wrote the offer, the buyer has no way out of the deal. And they're going to lose their deposit if they cancel. Another problem we're seeing is buyers writing things like, my offer is $5,000 more than the next best offer you get. That is enforceable. But what if the seller gets 2 offers like that? They both cancel each other out and neither offer is valid. Or maybe you get 1 offer like this and somebody else then offers 200,000 over the fair market value. You've now committed to 5,000 more than that. The point is there are risks to doing this that people need to think about. And by the way, we have on our website, we have these things called quick guides. We have a quick guide on making these escalation clauses. We have a quick guide on these non-contingent offers. We also have one on, sometimes appraisals aren't catching up with the offers right now. So people are saying my offer is 5,000 more than the appraised value or something like that, or 10,000 more than the appraised value. And the sellers accept that. The sellers don't really understand that they've just agreed to lower the sales price below the fair market value if that's what it appraises at. So sometimes the sellers don't understand what they're signing when they do that. And it's another thing, if your clients want to get creative with these offers, like regarding the appraisal contingency or regarding escalation clause or non-contingent offers, it might be a good idea to call the legal hotline or tell your buyer to maybe get their own lawyer to draft the addendum properly to make it say what they really think it means to say. We just have seen this happen over and over again. Another thing we're seeing is, just a couple of new laws you should know about. By the way, there's also a foreclosure moratorium for another month. Forbearance, your right to apply for forbearance has extended a little longer. And it looks like we may be getting from the federal government, not just eviction rental assistance, but there might be foreclosure assistance, mortgage assistance as well. So that if you're having trouble paying your mortgage because of COVID, there's probably going to be money available to you. Go to that same website, housingiskey.com, to see for the latest developments. I don't think it hasn't been put into place yet, but it should be coming soon. Lori, you're right. What about, not considering offers? Remember, the listing agent has a duty to present all offers as soon as practicable, and they definitely have to be presented before they expire. So if his offer is good for 3 days, the listing agent has to present it. And you're entitled as the buyer's agent to demand proof that they did present it. And if the listing agent doesn't do that, they're in violation of the rules and they can get fined. I mean, you do have rights as a buyer's agent to get offers presented. And what if the listing agent says, okay, we're going to present all offers on Saturday or something like that? Well, they need to tell everybody that, and they need to treat everybody fairly. What if they say all offers are going to be presented on Saturday and then it goes pending on Friday? Listing agent, what happened? Oh, well, we got this offer. The seller changed their mind. It was too good to wait on, so they just accepted it. I mean, that's legal if that's really what happened. If the listing agent really was really telling the seller everything that was going on. I mean, the bottom line is the seller's in control of how to handle these, but listing agents definitely have to, when you ask them, when was my offer presented, they have to tell you, and they have to present them. So if you have issues like this, just remember, as a buyer's agent, you do have rights, okay? That comes up a lot too. You're right, we're seeing that. By the way, randomly, did you know there's a new law that says homeowner associations have to allow at least 25% of all the property owners in the association to rent out their units? And if you have an accessory dwelling unit, you always have the right to rent that out, even if you're not living in the main house. And did you know now that there's a lot stricter rules now preventing cities and counties and HOAs from preventing you from building an accessory dwelling, prevent you from either converting a garage or something, or converting a back bedroom or building a new one. Generally, if you want to convert existing space, you can't be stopped. And even if you're gonna build a separate detached accessory dwelling unit, no more than a certain height, 16 feet, at least 4-foot setback, they have to approve it automatically. The point is this: if you are running into an issue, you or your client, with the city or the county or the HOA, especially city or county, and they're trying to tell you you can't build this particular accessory dwelling unit or something like that, or you have to pay this fee or something, or you can't rent it out or something like that, call the hotline, call CAR, because we actually have an attorney now who's basically, his main job is going after these cities and making sure they comply with the law. And he's very successful. He's 100% successful when he does this. So anyway, keep that in mind. That's about it really for the big stuff you need to know, I think. As I said, the big form changes. Oh, by one other thing, you may have heard about the Department of Justice settlement with NAR was terminated. Did you hear that? What happened was the Department of Justice, the federal government, sued NAR, saying you got rules that violate the antitrust laws. So NAR did a settlement agreement with the Department of Justice. Okay, we'll settle the suit as long as NAR agrees to do 3 things. Number one, they're going to make sure every MLS has a rule that the listing agent has to publish the commission to the buyer's agent on the MLS. Number two, you can't limit searches for properties based on the commission being offered to the buyer's agent. And third, you have to set up some system where non-members of the MLS still have access to the lockbox. Okay, so that was an agreement, right? But guess what? The Department of Justice backed out. How can they back out of a settlement agreement? Because it wasn't approved by a court yet. So we're back to square one. I basically think those 3 things that I just said are still going to happen, though. It looks like that's definitely going to, but there may be more problems with the Department of Justice. We'll keep you posted. Okay. So let me look real quick at Q&As you asked. Tanya, what about 1099 agents? I think you're asking about maybe the vaccination stuff. Sorry, I go back to that. Even though they're on your workers' comp, they're independent contractors. You don't have to keep a record of their vaccination status or anything like that. Okay. Yeah, you want to answer this? You want me to just ask me that? Did I get it right? Let me come back to that. Becky, on the RCSD, how does the seller sign documents the property is held in a trust? You're basically signing, the trustee signs, okay? So it should be signed as the trustee of the trust, but it's the name of the trustee who signs there rather than the trust. Doug, I think I may have answered this question on the fire hardening form. It asks if properties in a high or very high. On the NHD, it only gives very and wildland. I think I did address that. Yes, the wildland means moderate or high, so you have to push further with the NHD. Next one, anonymous. If an agent broker writes an offer and the listing agent sends back a counter, selling agent buyer accepts counter, raises price. I don't understand what that means though. Selling agent's buyer accepted the counter and raised the price. I mean, I assume the listing agents, they agreed to the raised price, never got a response from the listing agent, said sellers are out of town. Of course, it turns out it was a listing agent's buyer. I mean, if the buyer's agent accepted the counter and delivered it back, the question is, can you prove it was sent to the email address of the listing agent. You know what I mean? Was it delivered there? If they're going to say my computer was off, I was out of range, there's no way I saw that email, it's a question of fact. I don't know how to answer that one. Other than that, Jesse, on the listing, there's a coming soon status that seems to cooperate with clear cooperation. We were told you can no longer do coming soon. It depends on what people mean by coming soon. I mean, you're right. Once you start marketing, it's got to be in the MLS, but different MLSs have a different definition of how that all works. And we're still waiting for the ultimate guidance from NAR as to exactly what that means. Sandy, good point about maybe we should put something on our advisory regarding the drought, especially what's happening now. I think it's a good thing. I'll pass that along. Does a homeowner association in a mobile home park have to allow 25% to rent? No, what I was talking about is just homeowner associations, not mobile home parks. Wendy, can the HOA limit the time period of the rental period? In other words, I just told you HOAs have to allow at least 25% to rent. Can the HOA say, yeah, you can rent, but it has to be at least a year, can't be month to month? Well, you know what the law says? The law says you can't have unreasonable restrictions on their ability to rent. Is it unreasonable to require a year lease as opposed to allowing month to month? In my opinion, and every lawyer I talk to opinion, the answer is yes. They cannot demand a year lease. However, they can prohibit short-term rentals of less than a month. Okay, they can definitely prohibit that. Anonymous agents are requesting lockbox codes, giving them to your clients. How do you handle that? Have the agent arrested and thrown in jail. I'm just kidding. It's a violation of the rules. I mean, they should be reported and severely punished. Okay. Crystal, you closed an escrow yesterday, but you just got the FHDS from the seller today. Well, I assume the buyer doesn't want to give the house back. So my question to you is going to be, what does it say on the form? It probably says buyer. Did they check the box under 4B1 that says buyer agrees to do this within a year? Maybe the buyer is going to say, hey, they closed the deal. I never signed that. I'm not doing it. I think the buyer has the right to say that. But here's what I would tell the buyer. Whether you do it or not, if this property is in a high or very high zone, you're supposed to have 100 foot of defensible space. And a week from now, depending on where you are, CAL FIRE or the local fire company could just randomly come out to your property, see if you have 100 foot of defensible space. And if you don't, they could fine you. And they're not going to fine the seller, they're going to fine you. That's why my whole point on this FHDS thing is, to me, this law is not that big of a deal. To me, the most important thing is we should all have defensible space. And you should want to have defensible, it shouldn't be a burden to you. You should want to have defensible space to protect you. If you're in a high or very high fire zone, that means you're in an area where there are fires and you want to protect your house. So you want to have defensible space. If I were a buyer, if I didn't already, maybe what people are going to start doing is during escrow, buyer hires some private inspector to come out there to check and see if they're in compliance with defensible space. They just want to know. And if they're not, they're going to say to the seller, hey, you need to cut down that tree there. I'm not going to buy your house or whatever. You know what else I'm worried about? I'm worried about insurance companies are going to start automatically requiring certification of defensible space before they even insure the property. That hasn't been happening yet, but it might. Anyway, good question. Last question, are there any limitations on emotional support animals? Okay. I think what you're asking is, there's a no pet policy either in the HOA or the landlord. And the tenant shows up and says, well, you have to allow this animal because this is not a pet, it's an emotional support animal. Do they have the right to an emotional support animal? Well, two-step process. Somebody, not necessarily a doctor, but someone who was taking care of this person in some manner has to put in writing, yes, this person needs an emotional support animal. Could be a doctor, could be a caregiver of some kind, but first they have to present that to the landlord or the HOA. And assuming that's a legit person, okay, then they're entitled. But that doesn't mean they're entitled to any type of animal. They show up with a tiger or a lion or something. No, you can't have that. I don't care, it's emotional support. That poses a hazard to other people, etc. But what if they show up with, like, instead of one little dog, they got 3 little dogs? Is that okay? Well, did the person, I think unlikely, but did the person, like the doctor who gave this opinion, say, yes, this person needs so much emotional support, one animal isn't enough? You know what I mean? It depends on the circumstances, but they can't just do whatever they want. They have to get something from some type of caregiver, and the animal in question has to be reasonable. It's not unreasonably large. You know, it's not a Great Dane in a 600 square foot apartment or something like that. You know, it's got to be reasonably sized, I mean, not like any old animal, any species at all. But bottom line is, this is another one when it's a good idea, when this happens, to call the legal hotline or call a lawyer to tell them the actual situation, what they're actually asking for. So they're entitled to it, but there is restrictions, but it's based on reasonableness. Okay. All right, people. I think I'm done today. Don't see any more questions. Hopefully I will see some of you Thursday, which we'll go over the form again, and we'll actually look at the form and spend a little more time. I spent 15 minutes today. I'll spend more than that on Thursday at 10, just talking about all the fire hardening and the other stuff. You know, we're having another meeting with Cal Fire today. So next 2 days from now, I may have more information for you on how they're interpreting this. Okay, so that'll be good. So hopefully I'll see you then. And the rest of you, I hope I see you in person next year. I like to go out to see you guys, and can't do it, haven't been able to do it for a while, and probably won't be able to do much, won't be able to do any, probably the rest of this year as well. But anyway, Andrew, I think we're done here.
If you say so, then it must be true. So, sir, thank you so much. You know, it's great that if we can't get enough of you now, we can definitely double dip on Thursday.
Yes.
Everyone, keep an eye out from emails from your local association. We'll be getting that out probably today, so you can go ahead and sign up while it's on the top of your head. We'll also have this recording for you, so if you want to go back and review anything, and of course, I posted the CER legal hotline in the chat in case you want to call and talk to an expert. So everyone, thank you very much for attending this Region 2 educational event, and I hope you have a good day.